So it is my pleasure to introduce this interview of Professor Gloria Gaggioli, who will feature in our special issue on the uncertain future of human rights for global challenges. Professor Gaggioli, thank you very much for being here.
Thank you for the invitation.
Professor Gaggioli is the director of the Geneva Academy of International Humanitarian Law and Human Rights. She is also a professor of international law at the University of Geneva, where she is the principal investigator of a research project on combating and preventing terrorism and violent extremism, with legal and empirical perspectives on this issue, which is very timely. Today, we are very fortunate to hear you talk about different dimensions in the human rights regime. And so my first question to you is maybe if you could summarize for us what are the main debates about how human rights are implemented, how they are used sometimes for political purposes, whether they are still universal today.
Thank you very much for that. So when we think about human rights law, we can say that it has already made huge progresses because it's a rather recent branch of public international law. Mm-hmm. So first and foremost, I would like to say that human rights law has been quite effective overall when you think that before the UN Charter, before 1945, we didn't have international human rights law. Now we need to face several criticisms of international human rights law, and obviously there are problems. It suffices to look at what's happening around the world, and we can see multiple violations of human rights law on a daily basis. So on that basis, there are several criticisms that have been put forward. So one criticism, which is a rather traditional and old one, is the one that relates to the universality or lack thereof of international human rights law. So if you think about when the Universal Declaration on Human Rights Law was adopted in 1948, just before its adoption, you had the American Association of Anthropologists sending a message to the United Nations Human Rights Commission and saying, well, it's impossible to have a declaration that would set universal human rights. How can you do that? These are Western approaches that you are going to impose on others. So this has been really from the very beginning a criticism that we have heard. Nevertheless, the Universal Declaration of Human Rights has been adopted, and now we consider that most of it belongs to customary law. And so even if it was a traditional perspective, you can see new approaches, new narratives around this relativism of international human rights law. So nowadays, maybe it's less on the overall approach of human rights law, it's more on specific issues. But for instance, you can see arguments such as, well, when we fight terrorism, it's impossible to respect human rights, or at least terrorists do not deserve the same human rights as other people. Or for instance, certain communities, the LGBTIQ, when you look at the discourses in front of the Human Rights Council, that can be quite shocking when you see certain states really questioning the universality of human rights law in relation to specific groups or specific circumstances. But still, you do see a progress there. And from a positivist perspective and approach, we cannot say nowadays that human rights law is not universal. I mean, you will not find a single state around the world having ratified no human rights treaty. I mean, it does not exist. At least they have ratified a few. So from a positivist approach, it's clear that human rights law has become universal, but still questioning and discussing about the universality, seeing how it progresses remains important. Another challenge that we can say, and another group of criticism, is in relation to the politicization of international human rights law. So the Human Rights Council has been created in 2006 precisely to overcome the criticisms of the UN Human Rights Commission and the idea that there were double standards, etc. So that was really the purpose of the creation of the Human Rights Council. And to some extent, it has been successful. Now we have the Universal Periodic Review, so all states around the world are going to be discussed, and I mean the violations occurring on their territories are going to be discussed in front of the Human Rights Council. So there is progress, but still, it is a political body, and when you talk about a political body, you will always have political aspects. And so some countries, especially from the South, they are criticizing the Human Rights Council, saying, well, there are still double standards. We never have a resolution on the US, on China. Instead, we talk all the time about what's happening in African countries. Israel is always also on the agenda. So there is a sense that even if we made progresses since 2006, we still have an issue of politicization. And the last issue that I would like to tackle to answer your first question is the question of effectiveness of the system. So, and coming also from an IHL perspective, you know, I'm also an expert in international humanitarian law. My first reaction is, wow, human rights law, it's wonderful because you have so many monitoring mechanisms. It's a dream if you come from the perspective of humanitarian law, where you don't have monitoring mechanisms at the universal and regional level. So I mean, it's huge what we have in human rights law, so that's great. But at the same time, there is a lack of effectiveness of those mechanisms, or at least there is room for improvement. So for instance, you have backlogs of cases regarding individual complaints before the Human Rights Committee or before the European Court of Human Rights. So that's an issue. Or you have an issue also of overlaps. So treaty bodies dealing with the same thing, but still not communicating with one another. So lack of coordination of their activities. Or the reporting mechanisms. Normally the states are supposed to provide reports to the various 9 human rights treaty bodies at the universal level every 4 or 5 years, and it's not happening. I mean, if it's happening every 9 years, it's already a lot, right? So we do see that there is room for improvement, and we can work on it. But still, we do have a very solid basis of monitoring.
Well, thank you very much for this very exhaustive review of these 3 problems. If we come back to the last issue you just mentioned, the question of the coexistence of regional bodies and universal review mechanisms, how do you see this proliferation of regional bodies? Is there a threat of fragmentation of human rights law, or is it actually an asset that regional bodies and universal bodies work together, maybe as complement? Maybe could you expand a little bit on whether you think this existence of regional bodies is an asset to the human rights regime or not?
Certainly. Well, in my view, the regional aspect of international human rights law is a huge advantage. And it's not something new, really. Well, look at the European Convention on Human Rights Law. It has been adopted in 1950. So before the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights from 1966. So, I mean, developing at the regional level has been there from the very beginning of the evolution of international human rights law. And so in my view, it's an advantage in the sense that when you talk about regional levels, you can take into account the particularities that are present in those regions. And this is also a way to ensure the universality of human rights law. If we would have no particularism at all, it would be more difficult to have an appropriation of international human rights law by each and every region around the world. And sometimes you can see very concretely also in the jurisprudence of the regional bodies that it is useful to have this regional approach. I mean, the jurisprudence of the European Court of Human Rights is going very far especially on freedom of expression, freedom of association, on derogations. I mean, the case law has been very substantial. And then that has been used as a basis for other human rights bodies. So you do have also cross-fertilization. Other human rights bodies are going also to copy-paste some of the aspects that were already analyzed, for instance, by the European Court of Human Rights. Or if you look at the Inter-American Court of Human Rights, it had to deal with many armed conflict situations. So, for instance, you can see in the jurisprudence of the Inter-American Commission and Court of Human Rights a very broad and open approach towards international humanitarian law, something that was not existent in front of the European Court of Human Rights. Or you can see also that they go very far. For instance, the Inter-American Court of Human Rights considers that military tribunals should not be in charge of looking at serious violations of IHL or international human rights law because they have had the experience of dictatorships, of non-international armed conflicts in which the governments were fighting terrorist groups and where those military tribunals were actually not prosecuting war crimes. So they are very tough on that. And you don't have a similar approach in the European system because we were not faced with the similar issues. So I think that the strength of human rights law is to have, at the same time, you have the universal level with the Human Rights Council, we talked about it, with the treaty bodies, the work of the special rapporteurs, etc. And on the other hand, you have the particularisms of the regions that are taken into account. So I think that, no, it's quite positive, and probably even the decisions at the universal level, or the recommendations, because at the universal level you have only recommendations, but we could have a better monitoring at the regional level. So if we stay in Geneva, it's not very useful, right? So we can have beautiful recommendations, but if they stay there, it will not be useful. So bringing them in, really in the regions, in the states, having a better monitoring also at the national and regional level is very useful. And I think that's the way forward.
So what are the other reforms that could be brought to the human rights regime in its complexity and multi-level dimension that you could think about?
Yes. Well, there is a lot of work to be done, but we can talk about, for instance, the treaty body review.
Okay.
So there have been attempts in recent years to work on the effectiveness of the treaty bodies. We have 9 treaty bodies, and as I said before, you do have some overlaps. The individual complaints are not always dealt in a sufficiently short amount of time, so you have a backlog in relation to those individual complaints. You have a lack of transparency where we don't know sometimes why it takes so much time for some of the individual complaints. And so we do have all these issues. And so the treaty body review aimed precisely at trying to see what can be done to improve the effectiveness of those mechanisms. And the Geneva Human Rights Platform that is incorporated in the Geneva Academy works precisely on those issues. So, for instance, we have been recommending and advocating for a better calendar, you know, for the reporting mechanisms, because for the time being, many states do not do their reporting to the various human rights bodies. Of course, it's their responsibilities, but at the same time, the calendar is not well organized enough. So, I mean, sometimes they don't even know really for which body they need to do the reporting. So it's too complicated. Okay. And so simply bringing order then there can already help states to do the reporting mechanisms. Also, we are working with the Geneva Human Rights Platform on focused reviews. Okay. So meaning trying to also bring the reviews on some specific aspects, not necessarily discussing in the report all the issues that are, all the rights that are covered by a treaty, but just focusing really on key issues. And those focused reviews can be also conducted in the state and in the regions. So also bringing also the treaty bodies members in the regions, in the state, to discuss very specific issues. So these are the kind of concrete recommendations, concrete steps that can be done.
Thank you very much. So very interesting. So if we leave this general level of analysis and focus on specific issues, you have an ongoing research project on combating terrorism. And since September 11, many analysts have emphasized the fact that the struggle against terrorism has put a lot of strain on the human rights regime. So many analysts have talked about the Patriot Act in the US and in many other bodies like UN Security Council. My question deals with this specific articulation between counterterrorism and human rights. Can you think of ways of making them compatible rather than conflicting sets of prescriptions?
Sure. I mean, nothing would lead us to conclude that you cannot fight terrorism while complying with international human rights law. Mm-hmm. This is totally feasible. And you will have many experts, human rights experts, saying the opposite, saying, I mean, if you don't respect human rights law, you will fail as a state to fight terrorism. Mm-hmm. So definitely, they need to go hand in hand if we want them to work. But it's a huge challenge, because what we can see concretely, it's rather the opposite, that the fight against terror has been one of the most prominent situations where human rights law has been really completely violated. And it has been really used as an excuse to violate international human rights law. And the big issue we see also from an international law perspective is that somehow the framework, the UN framework, in a way favored those violations. Mm-hmm. So a first legal issue that we have is that we have no comprehensive definition of terrorism mm-hmm. at the international level. Mm-hmm. So we might think, okay, this is a technical issue, but it's not technical at all. Because then when you had the Security Council adopting, resolutions, so for instance, after the 9/11 attacks, mm-hmm. The Security Council adopted resolutions 1373 in 2001, and it was really requiring states to take measures to fight international terrorism, including criminalizing acts, which would be perpetration of terrorist acts, the planning mm-hmm. Of terrorist acts, or the financing of terrorism. Mm-hmm. So it was a decision based on Chapter 7 of the UN Charter. So states had really to also create new offenses, terrorist mm-hmm. offenses, to be able to fight international terrorism as required by the Security Council. But at the same time, the Security Council did not adopt or provide a definition of terrorism. Mm-hmm. So it's an open door for states to, consider that terrorists are also the dissidents, mm-hmm. the media, the human rights organizations, the civil society. So that is a real issue. And so you have seen after 2001, there has been a real proliferation of terrorist offenses at the national level. Mm-hmm. And many of those offenses do not respect the principle of legality. And they are not clear enough. You don't really know who would be covered by those provisions. Mm-hmm. And that's also linked to the fact that at the international level, the international community has failed to agree and to find consensus on an overall definition. Mm-hmm. So that's one of the examples that I can provide regarding criminalization, mm-hmm. but it's just one tiny part. Mm-hmm. So the criminal aspect. You have all the other measures that have been taken. So for instance, administrative measures at the international level and at the domestic level. At the international level, we talk a lot about sanctions. Mm-hmm. You're an expert in that issue as well. And so in relation to sanctions, we have had an approach of the Security Council to determine that states can select individuals, determine that certain individuals would be put on a list. So for instance, the Al-Qaeda list mm-hmm. and the Daesh list. Mm-hmm. And so on that basis, all states in the international community would need to implement sanctions that were dictated by the Security Council. And so those sanctions can go very far. So you have travel bans, so you cannot move around, you cannot leave your country anymore, the country you are in anymore. You have arms embargoes, the freezing of assets. And so when you see the cumulative effects of all these sanctions, which were applied in some cases for many years, this looks like a criminal sanction, although it's not. Technically, it was meant to be an administrative measure. And we have plenty of cases in front of human rights bodies which have criticized those sanctions and the effects they have had on the individuals who were targeted. So there is a famous case that was discussed by the European Court of Human Rights, the Nada versus Switzerland case. And Switzerland was found to be in violation with human rights law and the right to privacy of Mr. Nada, who could not really enjoy his right to privacy, the right to see his family and friends, because he was in an enclave in Ticino, so it's an Italian enclave, and he couldn't cross the territory of Switzerland to go to Italy, to mainland Italy, in order to see his friends and family. And so the European Court of Human Rights found that there was a violation by Switzerland of the right to private and family life, plus the right to an effective remedy. So you see very concretely that individuals who are targeted by those measures, they are in a situation that is almost unimaginable. You imagine you receive those sanctions and you have no way to challenge them. Neither at the domestic level, because the domestic level, the courts are going to tell you, well, it's based on a decision of the Security Council. We cannot do anything. I mean, the decisions of the Security Council prevail over your human rights. And you have no body to turn to at the international level. Of course, there is an ombudsperson. We had last week a conference, an event at the Geneva Academy with the former ombudsperson, Judge Kipfer, and with Special Rapporteur for Niaoline. And they discussed precisely this issue of sanctions. And when you listen to what Judge Kipfer was saying, you realize how absurd that can be.
Yeah, we also have a lot of debate on sanctions at the Institute. You know, my colleague Tom Bierstecker was thought about this reform of the UN Ombudsperson. My next question develops this similar trend of thought, and a lot of people have reacted to changes in administrative law that have been passed after COVID by actually also criticizing the limits that are placed on the enjoyment of human rights, the right to move. Also, we have seen many social movements against vaccination. What is your reflection about the way human rights are protected and enforced in the post-COVID era?
Well, that's an excellent question and a very difficult one, I have to say. Because it's true that with the COVID crisis, we have seen an unprecedented invasion of our freedoms. So obviously when you had the confinements, the lockdowns, when your children could not go to school, when you could not go to work, of course all these measures have had an impact on our human rights, civil and political rights, but also economics, social and cultural rights. So that's obvious, I would say. But at the same time, it does not mean that those were violations of human rights law. Because here you had states being in a true dilemma, in a sense, because it's the duty of states to protect our lives and to protect our health. So there is a duty to protect that needs to be implemented by states. And the right to health is obviously extremely important from that perspective. So on one side, you have this aspect, and on the other hand, you have the measures which lead to a limitation of many of our rights. So it's really about a balancing exercise. And when the impact is on so many rights, it's not obvious at all how to manage this balancing exercise. But obviously, as I said, it's not because you have those measures which limit our human rights that they lead to violations of human rights. This being said, the big issue has been that some states have used COVID as an excuse to curb human rights and to go beyond what was necessary to deal with this situation. So you take, for instance, in Hungary, I mean, the Orban government has been really deciding out of decrees for a very long time based on the COVID crisis. It has also adopted offenses which were going very far. So, for instance, if individuals would provide information that were considered as fake news, they could go to jail for that. So, I mean, you had offenses that were going very far and implemented by this government. Also, in terms of respecting the data of individuals. I mean, you have had a number of states doing tracking individuals to determine who was infected or not, and this without really having a proper data protection policy, right? So that's the real issue. The real issue is that some states have used the COVID crisis just to curb human rights and to go beyond what would be normally allowed. You had also multiplicity of derogations, and sometimes derogations were, I mean, it was meaningful to have derogations in some cases. So, for instance, for public hearings, if you cannot have public hearings, it would require a derogation from the right to a fair trial. So that you need to do, technically. Not all states have done it, but normally you should do it. But in other cases, in other instances, derogations have been adopted which were not really necessary.
You talked about the state's duty to protect in the context of the struggle against COVID and sanitary measures. The duty to protect is also an important concept as far as international humanitarian law is concerned. And I was wondering if we could shift to that topic and if you could talk about the articulation between human rights and international humanitarian law.
Sure. It's a topic that I love, the interplay between IHL and human rights law. And I think also it's one of the areas where the Geneva Academy has a very important added value. Because we do provide, teaching and research not only on human rights law, or not only on IHL, but on both bodies of law. Okay. And so it also goes together with a conceptualization of international law where these bodies of law are seen as complementing each other. And I'm personally truly convinced that to offer an effective protection to victims of armed conflicts, you need to have an approach which takes into account both bodies of law. Otherwise, you would have a number of gaps. And so you would be in a situation where victims of armed conflicts would not be totally covered from a legal perspective. So it's a very important topic, and it's a very complicated topic because I mean, when you look in the media, often you have a kind of confusion. Often journalists do not necessarily know the difference between humanitarian law and human rights. You have the word humanitarian in the wording, so it seems to be the same. But actually, these are very different bodies of law. The common point is, of course, that the objective is to protect the human beings. So it's the protection of humanity is behind it, for sure. But if you look at the fields of applications of those bodies of law, they differ completely. And the style of the rules are very different. So international humanitarian law is a law that is very precise, very technical. It's a law that was done by the militaries for the militaries, and it's limited to armed conflicts. So it's really to provide very clear obligations and clear prohibitions to the service personnel in the field when they are going to fight. Instead, international human rights law was meant initially for peacetime. Nowadays, we admit that it applies at all times, so also in armed conflicts. This is why you have an overlap between the two bodies of law. But the style is very different. So you have the prohibition of torture, the right to fair trial, freedom of expression, freedom of association. So generally, the rules are very, very broad, very general. They do not provide the details, and then you need to have domestic courts or human rights bodies providing more substance. So the style is completely different, okay? And the field of application are completely different. So we talked about when they apply. So here you see already a huge difference, as I said, because international humanitarian law applies only to armed conflict situations. But also when you look at the other fields of application, so for instance, who is bound by those rules? So from an IHL perspective, under international humanitarian law, all the belligerent parties are bound, which means that organized armed groups, non-state actors, are clearly bound by humanitarian law. This is not even a discussion for IHL specialists. It's admitted, okay? Instead, you look at human rights law, and it's different. I mean, for human rights law, the duty holders are basically states. And so saying that human rights law is binding upon non-state actors is not something easy. Of course, you will have huge experts like Professor Clapham who will explain you that nowadays we need to consider that non-state actors are also directly bound by human rights law. And I think he has very cogent arguments to say so. But not everyone would agree, and many states would say, well, no, human rights law is binding upon states, but not non-state actors. So here you see already a very important difference. Also where those bodies of law apply. In terms of geographical scope, you do have also differences. So for instance, under international human rights law, you have huge debate about the extraterritorial application of human rights law, especially when you have bombings, for instance. So recently we had the case Georgia versus Russia #2, where, again, an attack from Russia in Georgia, and we are in the middle of the war in Ukraine, so it reminds us of what's happening now. But in this case, the European Court of Human Rights considered that, for instance, when Russia was conducting attacks in Georgia, and before being the occupying power, during those hostilities, it considered that the European Convention on Human Rights Law was actually not applicable, that there was no jurisdiction. So here you see that the extraterritorial application of the European Convention on Human Rights is not obvious here. While IHL, for sure, it applies. I mean, you have hostilities, it can be, on the moon, it would be the same, it would apply. So you don't have the same dilemmas. So there are many differences between the two bodies of law. And in my view, those differences are the reasons why those bodies of law are complementary and why they need to be taken into account at the same time in relation to armed conflict situations to offer an appropriate protection to individuals. Otherwise, imagine if you didn't have human rights law, a victim of armed conflict or a person living in Ukraine today would have no freedom of expression. I mean, if you look at IHL, there is no freedom of expression, freedom of association, it's not there, right? So those rights are coming from human rights law. So it would be absurd not to consider international human rights law. So you really need to have both at the same time.
We are speaking at the time when there is a violent conflict in Ukraine, and as director of the Geneva Academy, what would you say is the role of the Academy in today's world, and what is its specific role compared to other bodies in Geneva which promote the protection of human rights?
Well, that's an excellent question, actually. We are an academic institution, and our mission is to transfer knowledge. So it's really knowledge transfer in relation to human rights law, international humanitarian law, with quite a big focus on armed conflict and post-conflict situations. So we are not an NGO. We are not there to do advocacy. But we are there to analyze situations and to provide also a critical account based on the law of what is going on in Ukraine. So for instance, now we have created something like the Graduate Institute did. We have a page on our website where you have interventions and blog posts, articles, interviews of all of various professors who are teaching at the Geneva Academy and who provide their views about what is happening in Ukraine. Yes.
Well, thank you very much for the time you spent explaining all these issues in their complexities and with a level of detail which I hope our viewers will appreciate. Gloria, Gaggioli, thank you very much for your time.
Thank you.